laws that prohibit the right to information in India were Indian Evidence Act 1872, Official Secrets Act 1923, Oath by Public Servant, Central Civil Services Conduct Rules 1964 and All India Services Conduct Rules 1968. From time to time, there were moves from government and private citizens for right to information. Because of these efforts, the government passed the Right to Information Act in 2005. Here are some right to information applications. The RTI Act of 2005 has resulted in lakhs of such RTI applications being filed every year. Officers of government and public sector enterprises have to respond to these applications as per the process laid out in the Act. As a government employee, you need to be aware of the Act. Your assistance may be required for responding to a query. This module will make you familiar with the relevant sections of the Act, the process of filing of an application and its disposal besides penalties. This module consists of the given units. The learning objectives of these units are: explain the purpose behind the RTI Act 2005, define the common terms used in RTI, describe the process to file a request under RTI Act 2005, explain the exemptions from disclosure of information, describe the process of appeal available to an information seeker, and define the penalties as per the RTI Act 2005. The duration of the course is 75 minutes. By the end of this unit, you will be able to explain the purpose of the RTI Act 2005. The Act was passed for setting out the practical regime of right to information for citizens to secure access to information under the control of public authorities, in order to promote transparency and accountability in the working of every public authority. The basic objective of the Right to Information Act is to empower the citizens, promote transparency and accountability in the working of the government, contain corruption, and enhance people's participation in democratic process. Obviously, an informed citizen can keep a better vigil on the government and make the government more accountable to the people. The basic purpose of the Act is to make its citizens informed about the activities of the government. To know more about the RTI Act, click the given link. Let us now recap the key points of the unit. In this unit, you have learnt that the basic objective of the Right to Information Act is to empower the citizens, promote transparency and accountability in the working of the government, contain corruption, and enhance people's participation in democratic process. You have successfully completed Unit 1, RTI Act Purpose. Move on to the Unit 2, RTI Act Common Terms. Welcome to the unit on process to file a request. By now, you must be aware that the Right to Information Act is a big step towards making citizens informed about the activities of the government. In this unit, we will learn about the process to file a request under RTI Act 2005. By the end of this unit, you will be able to describe the process to file a request under RTI Act 2005. Let us first discuss a request for information. Any citizen can apply in writing or online in English, Hindi or official language of the area. In case the information seeker is illiterate, the Public Information Officer or PIO must help him by converting the oral request into written form. The information seeker is not required to give any reason for requesting the information. He is only required to give his contact details or address so that the information sought can be sent to his address. The information seeker has to pay the prescribed fees. However, there is no fee for people below the poverty line. Click the icon to view a copy of the RTI application. If the PIO does not possess the information related to the request, he shall transfer the application to the relevant PIO within 5 days of the receipt of application. The information seeker should be informed about such transfer as soon as the PIO transfers the application to another PIO. For example, an information seeker's request for information from Gram Panchayat Secretary. Due to non-availability of information, the Secretary may forward the request to the PIO at the block level. Before we conclude, let's take up an activity. Given here are a few incomplete statements. Your task is to complete the incomplete sentence by dragging the correct option That's correct. Let us now recap the key points of the unit. In this unit, you have learnt that any citizen can apply in writing or online in English, Hindi or official language of the area, and there is no fee charged for information seekers who are below poverty line. You have successfully completed Unit 3, RTI Act, Process to file a request. Move on to Unit 4, RTI Act, Process to dispose a request. Let us start with a scenario. Suppose you have applied for a passport. You provided all the required documents. However, for the past 4 months, you are waiting for the passport to be delivered to you. Do you think you are eligible to know the status of your passport using the RTI Act? Select the correct option and click Submit. That's correct. After submitting an RTI request, it takes some time to dispose of the request for information. In this unit, Let us look at the process of disposal of requests for information. After submitting an RTI request, it takes some time to dispose of the request for information. In this unit, let us look at the process of disposal of requests for information. The PIO receiving the request for information shall dispose of the same within 30 days of the receipt of request. If the information is refused to an information seeker, the PIO should provide reasons for not providing such information. Further, he should inform the information seeker that time limit within which he can file an appeal against the refusal by a PIO to the Appellate Authority or AA. Let's next look at the same time limit within which the PIO should provide the information to the information seeker. The time limit to get information is 30 days for general information, 35 days if application is filed with APIO, 40 days if the interests of a third party are involved, and 48 hours for information concerning the life and liberty of a person. Let us look at an example. Here's an example showing the steps to calculate the time to dispose a request. Let's say an information seeker submits an RTI application with PIO on 3rd May. The PIO communicates about the payment of fees to the information seeker on 15th May. The information seeker deposits the cost of information on 30th May. Here we can see that there is a gap of 15 days between PIO intimation and deposit of fee by the information seeker. Therefore, the additional 15 days must be added to the 30-day period to furnish information. So, the date within which information must be furnished will be 16th June 2017. Let's look at another example. Let's say in the previous example, the information is not available with the PIO. Then the PIO transfers the request to the relevant PIO on 15th May and informs the same to the information seeker. Now, 30 days time will be given to the relevant PIO within which he should communicate the information to the information seeker. Let's say the relevant PIO processes the information and communicates the fee payment details to the information seeker on 30th May. Information seeker deposits the amount on 5th June. Here, we can see that there is a gap of 6 days between the relevant PIO intimation and deposit of fee by the information seeker. Therefore, additional 6 days must be added to the 30 days period to furnish the information. So, the date within which information must be furnished will be 21st June. Let's next know the fees and cost details. Wherever cost is involved, the applicant must deposit the fee before the information can be obtained. The central government has fixed the fees and costs involved for RTI application. They include application fee as applicable and A3 or A4 size paper, which costs ₹2. In case the sheet of paper is bigger than A3 and A4 size, the actual cost of the paper is part of the cost. In case information is required in floppy, it is ₹50. For CD, it is ₹100, and for DVD, it is ₹200. This cost may vary from state to state. If there is need for inspection of records, the first hour is free, after which ₹5 is charged for every extra hour spent on the task. Let us do a review quiz to check your understanding. Given here is the number of days and cases by when PIO should submit the information to the information seeker. Your task is to match day with the case and submit. That's incorrect. Let us now recap the key points of the unit. In this unit, you have learnt that disposal of request for information should be done as early as possible, not later than 30 days. If the official fails to give decision on the request for information within the period specified, the official shall be deemed to have refused the request. In case of life or liberty information, disposal of request should be undertaken within 48 hours, and when calculating the time for disposal, calendar days are taken into account, not working days. You have successfully completed Unit 4 RTI Act, Process to Dispose a Request. Move on to Unit 5 RTI Act, Exemptions from Disclosure. Let us start with a scenario. Delhi Development Authority or DDA acquired a piece of land owned by Subhash Chandra during a state of emergency. He received a certificate from the DDA in 1989 informing him that he will be given a plot of land apart from being compensated. However, he did not receive anything as promised. Subsequently, he wrote several letters to DDA requesting to honor its assurance. In the process, nearly 17 years passed. Finally, he filed a Right to Information (RTI) application with the DDA, requesting inspection of file notings and daily progress made on his application so far. The Delhi Development Authority replied that it would be difficult to locate the file as it was an old record. Can exemption be made on an RTI application on the ground that the record is difficult to locate? Select the correct option and click Submit. That's correct. By the end of this unit, you will be able to explain exemptions from disclosure of information. Avoid disclosure of information as per RTI if the information is prejudicial to the sovereignty, integrity, security, strategic interest of India, relation with foreign state, or may lead to incitement of an offence, is forbidden by court or tribunal, or may constitute contempt of court, is a breach of privilege of Parliament or Assembly, is in the form of commercial confidence, trade secret, or intellectual property. In the form of fiduciary relationship, is received in confidence from foreign government, is a disclosure that may endanger life or physical safety or identify source of information, impedes the process of investigation, are cabinet papers, and is personal information intruding into privacy of individual with no public interest involved. Click example to view it. In case of Divya Raghunandan versus Department of Biotechnology, April 13, 2007, the applicant had. In case of George, United Bank of Switzerland. In case of PPK, to know the RTI application can be rejected if no material information is sought or if the query is not covered by the definition of information, if it is information which attracts Copyright Act, if the information is so voluminous that it would disproportionately divert resources, if the safety or security of the document is in jeopardy, and if it attracts the provision of Section 24, Clause 4. However, public interest shall override exemption clauses. Click example to view it. An applicant had applied for information. An applicant, United Bank of Switzerland. If some information is sought by a citizen, first check whether the information is exempted. If it is not exempted by any exemption clause, disclose the information. If the information sought is exempted, check if the exemption belongs to absolute exemption as in Section 9, such as copyright or qualified exemption as in Section 8. If the exemption is absolute exemption, withhold the information right away. In case of qualified exemption, check whether there is public interest in disclosure or exemption. If there is public interest in disclosure, disclose the information even if the information sought is part of the exemption clause. If there is public interest in exemption, then withhold the information. Note that part information may be provided, severing the exempted portion. Let's look at an example. In the case of George Paul versus BSNL, appeal number 38/ICPB/2006 dated 29/6/2006. The applicant had appealed for a competitive cum qualifying examination conducted by a public authority and wanted information in nature of a copy of his answer scripts, as well as the marks obtained by him and marks of other successful candidates. The CIC held that the information in nature of disclosure of the evaluated answer sheets or scripts of examinees cannot be provided to the candidates, as there is a fiduciary relationship which exists between the examiner and examinee. The Commission held that this information falls under the exemptions from disclosure provided in Sections 8, Clause 1, Subclause E, and 8, Clause 1, Subclause J, Subclause I of the RTI Act 2005. However, the Commission ordered the public authority to disclose the list and marks secured of the other candidates to the applicant. Let's now take up an activity. Read the given case study and select the correct option. That's incorrect. Let us now recap the key points of the unit. In this unit, you have learnt that You are exempted from providing information if the information is prejudicial to the sovereignty, integrity, security, strategic interest of India, relating to foreign state, or may lead to incitement of an offence, and is forbidden by court or tribunal, or may constitute contempt of court. You have successfully completed Unit 5 RTI Act Exemptions from Disclosure. Move on to the Unit 6 RTI Act Process of Appeal. By the end of this unit, you will be able to describe the process of appeal available to an information seeker. An information seeker can file an appeal if the information asked is refused, only part of the information requested is provided, or he or she is not satisfied with the decision of the first appellate authority. In such a case, he can file a second appeal to Central Information Commission or State Information Commission. Here is the procedure to appeal. Click each tab to know the details. The information seeker should file for an appeal within 30 days from the receipt of such decision from the PIO. In case of sufficient cause, the time frame is extendable up to 45 days, and reasons for the delay should be recorded in writing. Appeal can be made to the designated first appellate authority. The second appeal is made to Central Information Commission or State Information Commission. Only the information seeker who has justifiable grounds for appeal can appeal. Any third party objecting to release of information pertaining to them, or an information seeker who is aggrieved by the decision of the PIO. The definition of members in an appealing process is given here. The information seeker submitting an application or appeal is referred to as the first party. Second party is the public authority responsible for processing the application. Third party is another person or body, including another public authority. Let us next look at the process of appealing. Given here is the process to appeal by information seeker. If the information is treated as confidential by a third party, then the following steps will have to be taken by the PIOs. Step 1. Within 5 days, the PIO has to give a written notice to the third party seeking his opinion whether the information should be disclosed to the applicant or not. Step 2. The third party has 10 days to respond to the PIO's notice. Step 3. In case the third party agrees for disclosure, the information can be released to the information seeker. Step 4. If the third party declines, then PIO has the authority to release the information as per public interest. If the public interest is greater than protected interest, then PIO informs the third party about his decision and releases the information with justification. Step 5. The third party can appeal within 30 days. Step 6. The higher authorities can take the decision to hold or release the information. If the third party does not appeal by the end of 30 days, then PIO has the authority to release the information. Let us next learn about second appeal. When can I make a second appeal? 90 days from the date of the decision of the first appellate authority if the decision is given, or 90 days after lapse of 30 days of the date of the appeal to first appellate authority. The Information Commissioner may admit the appeal even after the expiry of 90 days if there is sufficient cause. Let us look next at other sections related to appeal. In the exercise of its power, the Information Commission can require the public authority to take any such step to secure the compliance of the Act. By providing access to the requested information in a particular form, by appointment of PIO, and by making necessary changes to the practice of the public authority in relation to the maintenance, management and destruction of records. By enhancing the provision of training on the right to information for its officials, by imposing any of the penalties provided under this Act, by requiring the public authority to compensate the complainant for any loss or other detriment suffered, or by rejecting the appeal. The Information Commission shall give notice to its decisions, including any right of appeal to the complainant and the public authority. Let us do a review quiz to check your understanding. Given here are a few questions. Your task is to choose the correct option for the given question. That's correct. That's correct. Let us now recap the key points of the unit. In this unit, you have learnt that appeal can be made within 30 days from the receipt of such decision of the PIO. Where the appeal is against the order of the PIO in connection with third-party information, the appeal by the third party concerned shall be made within 30 days from the date of order. Second appeal can be made against the order of the senior officer to the Information Commissioner. Second appeal has to be made within 90 days from the date on which decision should have been made or was actually received, and the Information Commissioner may admit the appeal even after the expiry of 90 days in case of sufficient cause. You have successfully completed Unit 6, RTI Act, Process of Appeal. Move on to the Unit 7, RTI Act, Penalties. Welcome to the unit on penalties. By the end of this unit, you will be able to describe the penalties as per RTI Act 2005. Penalty shall be imposed for refusal to receive without reasonable cause any application for information or not furnishing information within the time limit without reasonable cause. RTI Act also specifies penalty in case of malified denying of a request for information, knowingly giving incorrect information, knowingly giving incomplete or misleading information, destroying information which was the subject of request, and obstructing in any manner in furnishing the information. The burden of proving or acting reasonably and diligently shall lie on the PIO. In case of persistent and serious violations, disciplinary action against the PIO shall be recommended. The Information Commission (IC) can impose a fine on the Public Information Officers (PIOs) of Rs 250 per day, subject to a total penalty not exceeding Rs 25,000. Only High Courts and the Supreme Court have the jurisdiction under the RTI Act. This Act does not apply to intelligence and security organizations notified by the central or state government like RAW, IB, BSF and others. However, even if such exempted organizations, information related to corruption and human rights violations should be given. However, even in such exempted organizations, information related to corruption and human rights violations should be given. Appellant Subhash Chandra's piece of land was acquired by the Delhi Development Authority. He received a certificate from the DDA in 1989 that he would be given a plot of land apart from being compensated. However, he did not get anything. Subsequently, he wrote several letters to the DDA to honor the assurance given to him. In the process, nearly 17 years passed. Finally, he filed a right to information application with the DDA requesting inspection of file notings and daily progress made so far regarding his application. The Delhi Development Authority replied that locating the file would be difficult as it was an old record. Not satisfied, he filed an application before the Information Commission. The Commission observed, the officer feels that the Delhi Development Authority almost has a right to misplace or lose a file only because it is old. The Commission would like to advise the officer sending such a reply to go to the National Archives at Janpath and see how more than 200-year-old records are preserved. It may be an education to her. The Commission also directed the Delhi Development Authority to pay compensation to the appellant, saying that the appellant went through a period of great anxiety and uncertainty because of the carelessness of the Delhi Development Authority for years. The order said no amount of financial compensation could be considered enough for putting a citizen through such mental torture. However, the Commission directs the Delhi Development Authority to pay Rs 50,000 as token compensation to him. The Commission feels that this amount should be recovered from the persons who have handled the file so casually. Let us do a review quiz to check your understanding. Given here are some questions. Your task is to choose the correct option for each question. Select the correct option and click Submit. That's correct. That's correct. Let us now recap the key points of the unit. In this unit, you have learnt that IC can impose a fine on the PIO of Rs 250 per day, subject to a total penalty not exceeding Rs 25,000. And in case of persistent and serious violations, it shall recommend disciplinary action against the PIO. You have successfully completed all the units of this module. You may now move on to the next module.